For those of you who are here in person, thank you for braving the Washington, D.C. heat to be physically present, and thanks as well to all of those who are plugging in online. We're here today to reflect on a very important legislative accomplishment, the recent amendment of the Toxic Substance Control Act, or TSCA, as we all know it. Not since the Clean Air Act amendments of 1990 have such major changes been made to a federal environmental statute. This was a long and persevering effort on the part of all those involved, and our panelists today being key among them. But in the end, compromise was reached, and a bipartisan bill made it to the Oval Office. And on June 22nd, President Obama signed into law the Frank R. Lautenberg Chemical Safety for the 21st Century Act, which is what brings us together today. ELI has partners, members, and friends on all sides of this process, and we've been following the developments closely for several years, and we celebrated when this legislation was enacted. I have to say, as a former general counsel at the Environmental Protection Agency, who saw the sun rise and set on a good number of other legislative reform efforts, I literally jumped up and clicked my heels at this stage, not with a lot of loft, but did it nonetheless. So we're very proud to host this event with such a distinguished panel to help capture the story of this important accomplishment. In part with the hope that that maybe this is a harbinger of things to come, that we'll see the Congress and other stakeholders come together more readily now to improve and update our other environmental protection laws. So again, welcome. I now want to literally give my chair to Jay Pendergrass, Vice President for Programs and Publications here at ELI, who will be serving as our moderator and introducing our panelists. Thank you.
Thank you, Scott. And we're going to move quickly to this. So the introductions will be brief. You can go on to our website on this and get more description of each of the panelists. But starting from my immediate left, we're very pleased to have all of our speakers, but starting with Senator Tom Udall, Senator from New Mexico and board member of the Environmental Law Institute. Then we have David J. McCarthy, Chief Counsel, Subcommittee on Environment and the Economy of the House Committee on Energy and Commerce. And Jim Jones, Assistant Administrator, Office of Chemical Safety and Pollution Prevention at US EPA. Lynn Burgesson, Managing Partner, Burgesson & Campbell, PC. Richard Dennison, Lead Senior Scientist at the Environmental Defense Fund. Sarah Brazina, Senior Director of Regulatory and Technical Affairs for the American Chemistry Council. And David Goldston, Director of Government Affairs at the Natural Resources Defense Council. We will start with Senator Udall, and we will take questions, short question and answer period for the Senator immediately following his remarks. Senator.
Great, thank you. So you're, good.
And that's just for the people on the thing, so it's not a...
So I don't even need it, you're saying, if I don't want it, right? Is that okay? He looks like he's happy. I don't have it, so let me, and I'm going to try, and Jonathan Black, who's my staff member that worked on this, is right here with me, and I'm going to try to stay the whole panel because I really want to listen to the others talk about this too, but I may have to exit before the end of this, and I apologize for that, but I'll try to focus on, Jay, what your assignment is to talk about actually getting it done and what it took to get it done, and then you'll hear from all the others here, and they played many key roles, all the other speakers you're going to hear. But let's just start at the beginning. This was a very, very broken law. It passed in '76. From 76 to 91, I believe there were about 5 chemicals that had been banned or regulated somewhat. And then in 1991, you had this ruling by the Fifth Circuit Court of Appeal called corrosion-proof fittings, which completely, from the agency's perspective, now the agency didn't appeal the ruling, but they felt that it crippled them. And it wasn't only them saying that. You go to the law books and you hear literally administrative law. It just says TSCA no longer works. It's broken, completely broken. And so that troubled me a lot, because I knew the country had come together around having a chemical safety law, and here we'd had a law that was broken 1991 till, we're talking 25 plus years. So serious problems. So that's laying a little bit of the background. I also want to just lay the background for the various bills. Senator Lautenberg was a real leader in this area. He always believed that this was something that was going to make a real difference. And he put a bill in 2005. So the positive things you're going to hear all of us talk about, and me talk about, and how it got done. From 2005 to about 2013, it was a war, and we weren't getting anything done, and people were throwing rocks and bombs at each other, and it just wasn't happening, and so you had a very dysfunctional process. So I just want to give that as part of the background before we start, because I think it'll lay a little bit of the it'll lay some of the bedrock there for all of us to react to. So in about 2013, Senator Lautenberg, seeing that, and I'm going to call this just for purposes of the bill that he carried from 2005 to 2013, I'm going to just call it the perfect bill. It's a bill that everybody would have loved to have had in certain quarters. Others didn't want it, but it wasn't going anywhere. And Frank became very frustrated, and he reached over the aisle and he got Senator Vitter from Louisiana. At the time, the Democrats were in the majority. So Senator Vitter is the ranking member on the EPW committee, and they put in a bill. He had his other bill out there, but it wasn't moving, and he put in what was the original Lautenberg bill. Now that bill immediately got an endorsement by the New York Times. A lot of people stood up and said, this is a good bill, this is a start on a compromise, and 6 weeks later, Senator Lautenberg died. I was on the EPW committee, and so this was something that I had been following very carefully and closely, and I thought, well, this is a great opportunity. Let's pick this up and make it go. And so what happened is after we had the funeral and I talked to Bonnie, it's Senator Lautenberg's wife, and the Lautenberg staff, we all decided, why don't we go forward on this? Why don't we do something in Frank's name? And so I had a dinner with Senator Vitter over at the Monocle, just the two of us, and we talked about, can we continue with this together? And he said he wanted to do it. We both came out of that with the idea that we were going to do this and that we were going to get it done. And so that was one of the keys, the really strong keys. First of all, Frank starting it out in a positive way. He had Frank's bill had immediately 12 Democrats and 12 Republicans. Very unusual in the Senate to see something like that. And I'm going to leave the most of the House side to the gentleman here on my left, which they did a brilliant job, and John Shimkus, Frank Pallone, and Gene Green, and Fred Upton, and Diana DeGette all worked over there. But on the Senate side, you had the Lautenberg bill, then you had Udall Vitter pick it up, and so we had about a year and a half in that Congress of very intensive negotiations. And one of the secrets, when you all ask, what's the model, how do you pursue it and put it forward, one of the things is keeping everybody at the table. The first thing is to say that people didn't necessarily want to be at the table. You know, they were tentative about it. There was distrust. I would say that the greatest amount of distrust was probably between the industry and environmental groups as to what each side was for, were they really willing to compromise? Was each side willing to compromise? And I think there was just a strong feeling of, you know, because you're here in Washington, you're hearing all of this gridlock, we're not going to really get anything done. And you see the 8-year history I talked about. But one of the secrets is keeping people at the table. And so we had folks at the table, made contributions. We always kept track of what the draft was and what the ideas were that were flowing in. And we moved through that. And we ended that Congress with a huge blow-up between a lot of the parties and especially senators in terms of where we were going to go. And at that particular point, I thought it was probably dead. I mean, Senator Vitter had said publicly, he didn't ever say this to me privately, but he said publicly, he said, you know, I'm finished with this. He didn't like how he was treated by others on the committee, and so he just said, I'm done with it. But we came, and so we lost in the election. So we come back into the next Congress. The Democrats go from the majority into the minority. And normally what happens around this place, you all know, you take advantage of being in the majority. So David could have put in his own bill and, you know, tried to rustle up Democrats for his bill. But he came back again. It was an example of him staying at the table. And if he had walked away, I don't know what would have happened. I really don't know what would have happened there. So we once again said, well, let's take the bill that was blown up and put it back in and start working on it. And so then the key process, and as I do it chronologically, I'll also add in the things that worked. And tell me if I'm getting Jonathan, you give me a sign if I'm about getting over time, one of you two guys, and then I'll do a couple of questions and then let these folks talk here. But one of the things we decided that we had to do, so you change Congresses, is we had to come out of that committee. And we were told by Senator Inhofe, you know, unless you can get a good bipartisan vote, we're never going to be able to get floor time from Mitch McConnell. And we only had, going into the markup now in the new Congress, we had one Democrat. I wasn't on the committee any longer. We only had one Democrat who was on the bill. And so that was Senator Carter. And that was really problematic. And so I recruited through the efforts of staff and all the folks here and everything, what we called the trio. And that was Senator Whitehouse, Senator Merkley, and Senator Booker. And we asked them, what do you need to go on this bill? Work with the parties that are out there, find out what you need. And they came forward with some very positive improvements, because I think it's fair to say that we were always improving this bill on the Democratic side in order to gain Democratic support. And then there was always very strong Republican support. And we were trying to do it even-handedly. One of the other things about staying at the table is we would we wouldn't get too lopsided in our co-sponsors. By the time we got the bill out of the Senate, jumping a little bit ahead, 30 Democrats, 30 Republicans. So we knew we had met the filibuster, but we didn't want it to be too lopsided. So we go into the markup, and we got it out of committee 15-5. And so that was a very strong signal, I think, to everybody at the table that we were serious about going forward on the Senate side. In the meantime, and you'll hear this on the House side, they were working very well, and they were quicker than we were in census as we move through this timeline here. So then the issue was getting enough co-sponsors. We had everybody working together, and to get enough co-sponsors that we could deal with the filibuster issue. And so when we reached that tier of 30-30, where we had 60, we were then able to get it through the Senate basically with consent. And after that, we had the very tough process. So we're through the Senate. The House had passed their bill in June. We passed ours in December. And then we had they're very different bills. And just to remark a little, it's not directly in point here, but the Senate legislates a lot with almost every senator, if they want to be involved in the bill, suggesting something, putting in ideas. And I'm gonna go to questions here right now. And the House, the expertise is in the committee, and so the committee and you're going to have to talk about this too, but they get really focused in, but not as many members, I think, know as much about the bill. And so that was a tough thing in order to try to bring the two together. But the thing that helped us, and one of the other lessons, is having good staff that are able to talk to each other. I think that's an incredible lesson. I mean, I put Jonathan forward as an example. I put this gentleman here forward as an example of how to do this in such a way that everybody feels like they're being listened to. And then to just to quickly talk about the folks that are here. I mean, we had environmental groups that always were willing to contribute things and contribute ideas and changes. Two of the ones, the Environmental Defense Fund and the National Wildlife Federation, were there and pushed very strongly from their perspectives. But I think a lot of the environmental groups wanted to see this thing improved over time and helped through that process I just talked through. Incredible in terms of the EPA. Very substantial behind-the-scenes technical advice. I mean, the one thing we wanted to make sure we did is not produce a law that wasn't going to work for Jim and his folks over at EPA. So with that, why don't I open it up, take a few questions, and then we'll go on down the line.
Sounds good. So, questions?
Senator Udall, we have one from the online audience first.
Okay, good.
Senator Udall, you don't come from what is traditionally considered a chemical-intensive state.
Right.
After Senator Lautenberg passed away, what made you decide to become a champion of TSCA reform?
Well, the first thing was, and you have to remember, most of the states in the United States are in this situation. New Mexico's unprotected with a law that wasn't working. So it's completely broken. So we didn't have a legislature that had the expertise to weigh in on chemical safety laws. We didn't have, like California did, set up a toxic bureau and had experts and was willing to review things. And so vast majorities of states in the United States had no protection because of the broken law. The second thing, I was always interested in this from, growing up in the Stuart Udall household where he had this wonderful friendship with Rachel Carson. And the two of them put out books, Silent Spring and The Quiet Crisis, right early in the 60s. And so just growing up, I kind of had the sensitivity to chemicals and chemicals' impact on the environment, on people, and that both of those should be healthy. And also be able to have a constructive dialogue with everybody else in the process. So that for me were the first two, and then the one that really as I dug deeper and deeper and deeper into this to believe that you had this court ruling and you really had nothing going on. I became very stubborn about the idea that I was going to persuade everybody this is so broken, anything's better. Anything's better. I couldn't believe it. There's nothing. As I kept digging deeper, I said, well, really now, what's been done? What's been done? And we say, oh, well, the states are doing a few things, but they're not doing it very well. And some states want to do something, but their governor and their legislature won't put any resources in. And so it was kind of a stubbornness and persistence of saying it's people, if they really look at this and they dig deep, they're going to find out it's completely broken, and they have to be willing, everybody that's at the table be willing to move forward. So we and all of the folks that are represented here along the line, I mean, I think made those steps forward to contribute. So, yeah.
Thank you very much. Probably have time for a couple more in the room if we've got them.
Not actually a question. I just wanted to say thank you.
Well, thank you.
Your role was tremendously important to getting this done. I really appreciate it.
One other thing, I won't take that as just a compliment. One thing that I wanted to say about political will. What frequently happens in Washington is, you put in a bill, and you organize the people that are for the bill, and you're willing to stand up and talk about it, but then do you have the next step of pulling together the coalition to move it forward? And then the next step after that is being willing to take the arrows. John Shimkus always stand up and say, you all took all the arrows on this. He took a lot of criticism. Many of the other members, I know the trio got criticism for some of the things they did, but this legislating is a tough business. I mean, you have to be willing to stick it out, and it was kind of the combination of the three things. Why did I do it? They all kind of kept motivating me, even though I had the sense I was spending all the Udall political capital. All that had been generated from the time my dad was in the Congress. I was just spending it like crazy, and I was at some point wondering, am I ever going to get it back? So, anyway, thank you.
Well, don't see any other questions. With that, I think thank you, Senator, for those remarks, and we'll now move to the other side, David.
Thanks, and I want everybody to understand, first of all, that everyone in the House has so much admiration for Senator Udall, as former House member, but his leadership in this was absolutely indispensable. We saw that from the House side. We saw it every step of the way. There are several people for whom, you can say, sine qua non. Without them, it doesn't happen, but I don't know if anybody as much as Senator Udall in that regard. So here's the story of the House. Senator Udall got you the first part of that story. In the 2013-2014 Congress, we in the House Energy and Commerce Committee had several TSCA hearings. These were very, very important because we had very few members who knew anything about TSCA. There was a great deal of stakeholder interest in doing legislation. And our charge from our chairman, Fred Upton, was get this work from day one toward getting this enacted. We're not playing messaging games. This is for enactment purposes. And to do that, you've got to build genuine support, and that means members have to have buy-in. What you heard from Senator Udall was also true in the House side. I only started on the Hill in 1980, but I have never seen a piece of legislation that had so much direct member involvement, and I'm talking about hours invested directly by members, as this one. Nothing even comes close to this, and that's probably true in both bodies. So to build that in the House, we had to have hearings on various aspects. I'm looking at people in this room who testified before the House in those hearings. Then we stepped up to the attempting legislation. In 2014, Henry Waxman was the ranking member on our full committee, and so we were working with him and his staff, and with and Senator Udall is absolutely correct. Congresswoman DeGette, Congressman Gene Green, John Shimkus, all in the room for lots and lots of hours, going painstakingly page by page. We did some at the staff-only level and a lot at the member level. And it was interesting because when the members were in the room, things got a little bit more agreeable, So So then we realized at a certain point in 2014, it just was not going to happen that year. And whether, the election year realities kind of overtook us on the calendar or what, but, people began to okay, it was probably not going to happen this year. So by the August recess of 2014, we were already in TSCA post-mortem phase. So the question was, wow, how come we failed? What could we have done better? Could we try it again? So we started thinking it over. When we came back in 2015, and we didn't know until, I guess, January of 2015 that Frank Malone would be the ranking minority member on our committee. And shortly after he got the word that he was the leading Democrat on our committee, the members sat down and said, yeah, we want to do TSCA. We really want to do it. So they gave us a charge to the staff to see what you could, see what you could explore. At this point, members were very, very interested, but also cautious and careful. So we sat down at the staff level and had a conversation. And we'd already had this conversation a little bit at the member level about trying an approach that was different from what we had done the year before. The year before, the bill was a little bit more closely followed to what ended up being the law, an outline of the legislation that pretty much ended up becoming enacted. We felt that a lot of the detail in that original effort for us had bogged us down. So we decided to try a simpler approach, to first ask the question, what is the essential thing that you're trying to accomplish with TSCA reform? And Senator Udall nailed it. Step one that we agreed to in the House was get rid of least burdensome. That was the case that Senator Udall cited. We didn't discuss that more than 15 seconds. That was, okay, we have a deal on that. Now where do we go? Let's focus on Section 6. And so we'd already had this concept the year before where we bifurcate the risk evaluation from the risk management. So we're going to have a risk evaluation that's based entirely on science, the science of risk, which is exposure and hazard, and analyzing those. And at what point is the risk, is there a significant risk? Or I should say, at what point is there an unreasonable risk? And then once you just identify a risk, then you start talking about bringing in the practicalities, economics, costs, availability of alternatives, all that stuff. So we agreed on that, and that to me was a big change in current law, both those things. That's frankly a pretty profound change. So just doing that alone got us off to a good start. So then we started filling in some blanks around that, looked at other sections that required changes. If you're going to make those changes, you got to make some changes in Section 4 testing and elsewhere. And then we started we kept kind of postponing, so to keep ourselves together for as long as possible and build as much bond, sort of like when you're trying to glue two things together, just keep them glued together before you start pulling them apart. That's why we kind of put off the preemption conversation for a while. But we had to do it, and we did it. And so we came up with a solution we thought on preemption that was obviously that both sides could agree to. In some ways, not quite as ambitious as the Senate, but in other ways, shorter and simpler. And so we reached agreement on that, and we were ready to go to markup. So in the House, these stages are, first of all, you have to put documents out for subcommittee markup. So at 3 or 4 stages, we had public versions of the bill, and they changed from time to time. From subcommittee to full committee, they changed. And then after full committee, we had a little bit more negotiation. We were going to the floor. Now, here's where it got interesting. We had felt all along that to be successful in enacting law, it had to be strongly bipartisan. We have President Obama, we've got then Speaker Boehner, later Speaker Ryan. We had to be bipartisan, and we also had the Senate. And we knew that the Senate's not going to do something that comes over from the House that's on a party line vote. That would just kill it. I mean, we've seen that happen with other legislation. So we've got to keep this bipartisan thing together. And bipartisan is one thing, 2/3 is another. I mean, now you're talking a real challenge. So I got a phone call from the House leadership. He said, hey, Dave, think we could do your TSCA bill on suspension? I said, wow, I took a deep gulp. I said, wow, that means I have to have 2/3. And I have to promise you now that you will get 2/3. because I should be fired if we don't. You don't put the House leadership and the whole House through a humiliating exercise by the way, the process for suspension means the bill cannot be amended. It's only debated, I think, 40 minutes at the most. And then you go to an up or down vote, but you have to pass by 2/3 of the House. 2/3 is a very, very big number. I mean, it's a high, high mountain, okay? So I've got to promise now to the leadership whether I can produce 2/3 of the House. That means I have to produce virtually all Republicans. I can't give up very many Republicans because I'm assuming I'm going to lose some Democrats. We are in the majority after all, and there's a tendency sometimes for people to be cautious about voting for majority measures. So the first person I called, of course, was Jackie Cohen, my counterpart and my dear friend and one of the best lawyers I've ever met in my life. I called Jackie and said, Jackie, you're not going to believe it. Leadership is asking if we can do it on suspension. She said, I can hold my guys if you can hold yours. Wow, what a challenge. Now, here's another reason it was a challenge. We've been on the House floor just about a month before that, maybe 2 months before that. We had this simple little bill that was addressing the problem. It was Jim's agency, algae and drinking water, particularly in Lake Erie. Very simple bill. It just said, gave EPA the tools to work with other agencies, come up with a strategic plan to address this problem because people were just getting their water shut off. Everybody's for that. It didn't cost anything. CBO scored it at 0. What could be a problem? I go to the House floor with that bill. It's put on suspension. I have 50 Republicans vote no because they heard a rumor it did something for EPA. I'm going, oh my God. I mean, how am I supposed to get this thing on suspension? This one really does do something. This TSCA bill, I can't say it's not a nothing burger. Okay, this is a real piece of legislation, and yeah, it does something for EPA. And EPA will be a lot more active in chemical regulation when this bill becomes law. So I'm thinking, if I lost those 50, who else do I lose? I mean, I can't control this, and we don't. In the House, it's just you're never really sure, until you have that moment. So Jackie said she could hold hers. I said, okay, we'll hold ours. And I guessed that we would probably get 10 or 15 north of 2/3 because I knew. And by the way, we of course discussed it immediately with our members. Fred Upton and John Shimkus felt confident. They said, yeah, we'll lose a few, but don't worry, and we'll work them on the floor when the time comes. We'll just have members do. And this is in the House. Senator Udall knows this. There's a lot of persuasion that goes on during the vote itself. So we didn't need that this time. We got lucky instead. We have the debate on a get-back day, which is a Monday. The end of the debate goes very nicely. Everybody's for the bill, of course. Of course, there's only about 4 or 5 people on the floor. This is before the first vote of the week, so they're all arriving at the National Airport while we're having this conversation. So the votes are rolled. That means that they postpone the actual votes on the bills that were debated that afternoon until evening. We come back to the floor that evening to vote. The first vote of the day is a suspension bill. It's not ours. I forget what it was, but it passed, but not by much more than 2/3. Wow. So then ours is going to come up. Just before ours comes up, I'm noticing these members gathering in the well of the House. Of course, I had to be on the floor for the vote. And all of a sudden, the members, of course, all 435 members are present because they just voted on the last one. So all of a sudden, the House starts to get quieter. The Speaker starts rapping the gavel, gently, very gently. And the Speaker starts making a motion to people to sit down. Just everybody sit down. What is going on? What now? Expect the unexpected. I can't imagine what this is going to be. So there are 4 or 5 members, and I noticed what they all have in common. They're from South Carolina. One of them gets up and says, Mr. Speaker, I ask unanimous consent to address the House for 1 minute out of order. Oh, God, what now? He says, when the arraignment took place, each of the victim families went to the courthouse and said, I forgive. He was discussing the shooting at the church in South Carolina. I'm telling you, you never saw such a poignant moment in your life. Members were literally holding hands with each other. They bowed their heads in prayer. And at the end of a minute, you hear the gavel rap. Question comes now on final passage, TSCA Modernization Act of 2002. All those in favor say aye, opposed no. Bing, bing, bing. A lot of green lights going on. Everybody's very agreeable in this moment. So it ended up, what was it, 412 to 1 or something like that?
398.
Oh yeah, it was there were a couple of minutes.
398 to 1.
Right. But the one I was rather proud of, he put out a press release why he voted no, because it repealed least burdensome. And the reason I was proud of that was it shows that our House members actually read the legislation. So that's basically how we got through the House. And then, of course, the Senate passed a bill that was different, contrasted in a lot of ways in December. And then we got to work on trying to work out those things, and it ended up, Jim got done. And the role toward the end that Jim Jones played, certainly with the House side, was absolutely indispensable. Jim's technical, not just technical advice, but his leadership on guiding the language and helping us to agree to things that we were uncomfortable with in the Senate. And if Jim was okay, we got it. We understood we're giving Jim a lot of responsibility, including a lot of interpretive responsibility, but we felt comfortable with that.
Thank you very much. And we will turn it now. And we will turn to Jim Jones now.
All right. Well, thanks. It was an amazing experience. I had an incredible time working with all of the people here. The staffs in the House and the Senate were remarkable in the degree of integrity and creativity and problem solving they brought to us. It was an amazing career experience for me, which I'm very grateful to have had. EPA, I come to it relatively soon compared to some of the folks up here. I'm a former career person at EPA. I have a political job, but in 2009, when President Obama came to office, I was in a career position as the deputy head of the office that I'm in right now. And right out of the gate, President Obama, Lisa Jackson, the administrator, said, this is a priority for us. We want to see TSCA reformed. The White House then convened a number of offices within the White House and EPA, and we articulated our principles for TSCA reform. And that came out in the summer of 2009. Steve Owens, who was the assistant administrator at the time, who I was working for. I actually went back and looked at them today. Not for the first time. I looked at these principles all the time throughout this entire process, and I recommend them to everyone. They line up quite nicely with the bill. I think that we had our arms around, as the executive branch, what was wrong with TSCA. We understood what the problems were, and I think that the solutions that we were recommending in the summer of 2009 are beautifully represented in a very good piece of legislation. We use those principles pretty much to guide us throughout the process, and for anyone who wonders whether or not it's good to have principles, I can tell you it's good to have principles. It can really help you out in a lot of tough situations. I think it probably applies to more than TSCA. So we basically use these principles to guide our interactions with the Hill. As you heard, there were a number of hearings in the Senate as well as in the House. Things really began to pick up, as Senator Udall said, after 2013. And although there were a number of hearings before 2013, they were largely related to the then Senator Lautenberg bill, for which there was just not much bipartisan support. But we basically used our principles to guide sort of how we talked about the bills and various provisions of the bills and how a provision lined up with the administration's principles. The principles basically spoke to the fundamentals of what we thought needed to be addressed. And so that defined our participation at a public level throughout the hearings process as the Senate and the House built the record for how they wanted to address the bill. And then as you heard from Senator Udall and Dave McCarthy, behind the scenes, we were providing technical assistance to, our MO was if the Democrats or the Republicans in the House or the Senate were asking us for assistance on a provision, we were going to give it to them. And so we had literally hundreds of interactions with the committee staff, House and the Senate, regarding provisions that they were working on. Some of them iterated dozens of times as the engagement, as various members would weigh in and staff would weigh in, things would circulate round and around and around until they would land. And we pretty much gave our best advice about how to draft the language. Two things in mind. Is it doing what they think that it's doing, which is often a trick, and can it be implemented? If there was something that was outside of the context of the administration principles, we would point that out. But at that point, our principles were so well known and understood. That didn't happen very often, actually. Most of our assistance at that point was, is this going to do what you think it's going to do, and how well or easily could it be implemented by EPA? I think everyone had their eye on that ball regarding implementation by the agency. The next sort of real public statement engagement that the agency made came on January 20th, actually, of this year. So now, as you've heard from Senator Udall and Dave McCarthy, after December of 2015, we now have 2 bills, and they're very different in many respects, but they also had very similar provisions to them. Sort of how they got things done was different pretty dramatically in some cases, but what they were trying to do was very similar. And so at that point, we felt that it was important for us to be public about what we thought of various aspects of each of the bills. And so at the end of January of this year, before the negotiations between the House and the Senate got too far along, we weighed in, Administrator McCarthy weighed in with a rather lengthy letter to the leadership of the House and the Senate, basically articulating the key provisions and which ones we thought were closer to the administration principles, as well as preferences related to interpretation and implementation. It was quite a long letter that covered much of the guts of both the House and the Senate bill. But in a cover letter, the administrator reinforced what she thought were the most important aspects for the Congress to keep their eyes on, and that is a workable safety standard. One of the big problems we had with the former TSCA was the safety standard itself. It's not workable. Least burdensome was a piece of that. Not the only part, but one of the parts. A workable safety standard, the importance of deadlines, which is something she really emphasized, that if you don't have deadlines in a statute where there's a lot to do, you're going to find yourself over time in a not getting much done, and the importance of adequate funding for the agency. So she really wanted to highlight those 3 elements, and elements of each of those were captured in both bills, but she really wanted to highlight them, and we believe the bill addressed all of them. The other thing is, as we sort of, would talk about how we should be engaging and posturing and speaking about this bill, is the administrator said to me after the early days in 2013, I think, when things were like, well, we got something bipartisan going on here. And I went into her office one day to give her an update on it, and she asked me, how's it going? I said, well, it's better than current law. Stop right there. That is not the test. That is not the test the administration is going to bring to this. Let's go back to the administration principles. We want a bill that gets the job done. That's the test. That's how we should be engaging in this. That is what our principles were about. So let's stop talking about better than current law. Let's talk about getting a bill that gets the job done. And it was very helpful for me to get that reframing of the issue. And it is how we wrote the principles. We didn't write these principles about what would be. The principles of what would be better than the current law that would be short, because almost anything would have been better than the current law. So that is how we engage. It was, as you heard, it's very technical in its orientation, but guided by a lot of substance that was articulated very early on in the administration. And I believe that the things that we laid out now, it's seven years ago, have been met. Very clearly have been met in the bill that passed last month. So we're pretty jazzed about it, and we're pretty excited about implementation. The other thing I said, a little bit exhausting at the end, because there's a lot of technical neediness there the last couple of months, and so we were giving a lot of technical assistance. It was going on 7 days a week for several months, and so we're kind of tired at the end, and I'm like, oh, geez, I really can't think about implementation. This is going to be really hard. And within 2 days, when I start to actually go back and refresh myself with the bill, it just dawned on me. I was like, well, unlike the legislative process where I am a fish out of water, I'm like, I can't quite get how you guys operate. It's a different world for me. And like, oh, administering an environmental law, I know what I'm doing here. So that alone refreshed me, and people at EPA are very excited about implementation, and I think we've actually hit the ground running. So we're very excited.
Thank you. And Lynn.
Jay, thank you very much, and great to see everybody. I have a little confession to make, and that is, despite my presence here, and unlike everybody around to my left and right, I was not in the room where it happened. I wish I were, Dave and Senator, given your accounts, this has all the drama of a Netflix series. House of Cards to shame. We need to get you on the next segment. That was very compelling. What I am, however, is a long-standing TSCA stakeholder, a parent, a lawyer, a citizen of the United States, and have been deeply committed to reforming a very broken law for literally decades. The law needed an modernizing, and what we have here, since we've been spending so much time on your handiwork, is an elegantly written, balanced, and entirely implementable law that will make the world a better place. I wanted to just give a couple of remarks keying off of the policy of TSCA in TSCA 2B. Now, we've been really studying it for a long time now. Richard and I were on a webinar this morning, and Richard gave a remark that reminded me that there are 3 components to the policy supporting TSCA. The first of which is EPA needs adequate information in order to make informed judgments. TSCA Section 4 in the new law fixes that. You get new authority to issue orders and to compel information for prioritization purposes, and that is a much needed element in the law. EPA needs to have adequate authority with respect to managing existing chemicals. The revisions to TSCA Section 5 and Section 6 are balanced and will be effective in giving you the authority you need to do the job. So that's good. The third component of TSCA 2B goes to exercising that authority in a way that does not unduly burden or frustrate innovation. And as a practitioner representing largely many chemical innovators using evolving technologies, nanotechnology, and biotechnology, and synthetic biology, I think this is going to be a provision that will require a great deal of thought in managing these competing interests. But I know, Jim, you and your team, and we as a stakeholder community, we're up to that task to make sure that the balancing is done in a way that continues the innovative process, but also allows the agency to do its job with the authorities that it needed. So I look forward to working with the agency and others, and I want to thank everybody, Richard and Senator, your team, Jonathan, all of the people that worked totally selflessly, endlessly, to make a really good law. And we as practitioners in Washington and elsewhere need to do our job to make sure that implementation process goes well and effectively. So I'll cede the floor to Richard.
Thank you, Lynn. Richard?
Thank you, Lynn, and thank you, Jay, for the invitation. It's a pleasure to be here. Along the way in all of the post-passage webinars, seminars, receptions, etc., the analogy of climbing a very, very tall mountain, one of the world's largest mountains, as the way to think about how TSCA reform got done has been put out there. And I think that's an apt metaphor, if you will, for it. And just to sort of beat that metaphor a little bit, first, you aren't going to do it in one climb. And that's absolutely been the case. Senator Udall mentioned that the legislative part of this journey started in 2005. And bills were introduced in every single Congress, in that one and thereafter, each time getting more and more momentum. But that's how long it took just on the legislative piece. There was a lot of stuff that happened before that. Activists at the state and national and local level, health groups were driving this issue under the national agenda through their work to get states to be acting in the absence of federal action, to get the market to be acting. That was critical to getting this onto the national agenda and under the Congress's agenda. You can't begin to think about doing it by yourself, climbing that mountain. This was an achievement that took thousands of people doing thousands and thousands of hours of work, all taking different approaches, all bringing their own expertise, their experience, and their own approach to pushing it forward. There's been a lot of debate and so on about who was in the room, who wasn't in the room, what role different people played. My view is that all of it was necessary. Absolutely all of it, and it wouldn't have gotten done. You need to establish and maintain and attain multiple base camps along the way when the climbing is very high now. Well, Senator Udall did a great job of laying out some of those base camps that were established. It started with a small circle, and it ever expanded as more and more support was gained in exchange for improvements being made to the bill. That happened in the Congress. It happened outside the Congress. I want to point to one or two other factors that I think haven't been mentioned yet. I fully agree with the ones that have in terms of how this happened. One of those is the shift that happened in the industry's position in 2009. And I have to give a lot of credit to Cal Dooley coming into the American Chemistry Council and deciding that the position that the industry had taken for too long of opposing reform and believing that law just works just fine needed to change. And that was a major shift that began to create some common ground. It started to highlight a mutual interest across all the stakeholders in having a stronger federal system. The industry began to realize it needed one to start restoring confidence in the safety of its products, and the health and environmental communities needed one to make sure that we were in fact looking at chemicals and getting those that were posing risks restricted. So that common ground, even though it was motivated by very different motivations, created a place where dialogue could start to happen. There were lots of informal dialogues off the Hill. There were lots of more formal dialogues on the Hill. All of that, some in the House. I remember those meetings in the House. Jerry Curry was very involved in those, Dave. Back in 2010, Lautenberg and Inhoff's staff started having staff meetings. Ben Dunham and Dimitri Karakitsos were meeting with stakeholders in that period of time. That was critical to start defining where the boundaries were, what could people live with, et cetera. EDF played a role here that has been criticized in many quarters and has been misunderstood, in my view, in many places. And I'm going to take a couple minutes here to describe the role we took and why. In 2013, as Senator Udall already described, when Lautenberg and Vitter put out their bill, we had a choice to make. And we were asked to make that choice by Senator Lautenberg and his staff. Could we support that bill as a place to start? And would we put EDF's name behind that bill at that time? Having had very little time to even look at the thing, and understanding that it had problems that needed to get fixed. We decided to take that risk, and we did it for 4 reasons. One, Senator Lautenberg asked us to. He was the longtime champion in our community on this. We needed and wanted to support him, and he was asking us to do this. Two, despite the flaws, both the ones we understood at the time and the ones that we understood as we looked at it more, it had a lot of the seeds of the reform that we ultimately needed. It struck least burdensome. It separated the safety decision about a chemical from the risk management decision with regard to costs. It had the idea of order authority for testing. It gave states access to confidential business information for the first time. Those were some of the seeds there. There were other big problems with it. There was overly prescriptive and, frankly, industry-leaning science-related language throughout the bill. There was sweeping preemption of state authority. We recognized those problems, but we believed for 2 reasons that it needed our support. One, without any support from our community, I am very convinced that bill would have died. It simply would have died. It would not have gotten off the ground. And we had 10 years of experience before that with that exact scenario playing itself out. And 2, we became convinced that the only way to fix those problems was to move the bill through the legislative process, to get people to engage, to make changes in exchange for their support, and broaden that. And that was a way not only to build support, but to sustain momentum over
more than one Congress to ultimately get it done. I believe that was the right choice. It's a little bit easier to say that perhaps in hindsight than I felt along the way sometimes, but I did want to spend a little bit of time pointing that out. I want to give you one example of a place where just where the substance hits the process here, and that is this extremely contentious issue of preemption and how to strike a balance that was both politically and substantively viable. We had some critical priorities for us as an organization in that battle, and many other people in this room and outside this room had other and additional priorities, all of which came together to ultimately create the package that ended up in the final bill. For us, the most critical pieces were to ensure that any preemption that attached to EPA actions under this was limited to the same scope of those EPA actions. In other words, if EPA only looked at certain uses or risks of the chemical, that's the extent of preemption. And the second principle was that preemption should only attach to chemicals that were either going to undergo or had undergone a full-blown risk evaluation, soup to nuts, with access to all of the information necessary to inform that. That meant new chemical reviews, which I think are greatly enhanced under the bill, but they don't meet that mark, and there should be no preemption for those decisions, and that's the case. It meant low priority designations, which was a very controversial part of that original bill, should not have preemptive effect because they're not based on that full assessment. So those were the kinds of principles that we fought for. Many other people contributed to making that final package of preemption provisions acceptable and able to pass in both houses. But I want to give that example as a place where a lot of this dynamic and the give and take and the improvement over time really played itself out. There's other ones that we could talk about too, but I'll stop there. Thank you.
Richard, thank you. And Sarah.
Thank you all, and appreciate your time today. I thought I'd give just sort of answers maybe the burning question that some of you have wondered about. How and why did the chemical industry get its arms around supporting changes to TSCA and modernizing TSCA? And I think historically, you need to go even further back than we've gone. Go back to the late 90s, and the chemical industry and ACC in particular have, of course, always had a responsible care program, always looking for, improving its performance. And there were voluntary programs that EPA and EDF helped develop with ACC, the High Production Volume Chemical Challenge Program, and the Voluntary Children's Chemical Evaluation Program. We were all trying to, look at this question of, is there sufficient information on which EPA can make decisions under TSCA? And those were programs trying to get at the information needs of TSCA. Obviously, that was just one piece of the puzzle. And, move forward to things that were going on around the world. The Canadian Environmental Protection Act, the EU REACH program, beginning conversations about that. Our members, the chemical industry is a global industry. They're not just complying with U.S. laws, they're complying with laws all around the world. And so they started asking, questions about, what was going on there, what could we improve things here. And then as states started, as Richard just mentioned, passing their own chemical-specific bans on a more increasing rate, and even retailers, big retailers, started demanding that their suppliers look at the chemicals in the products they were selling and ask whether those, in fact, should be deselected. So pressures from around the world, from retailers, from states, and our board of directors looked at this whole question of our position on TSCA, given all of these activities at a voluntary level and global level and state level and retailer level, and asked, do we need to change our position on status quo relative to TSCA? And in 2008, actually before Cal Dooley came into ACC, the board of directors adopted a change which said we support modernizing this old law, and then gave the job to people like me to work to try to figure out what did they mean by that. They laid out some principles, and we, our committees are, the chemical industry is made of brilliant people, chemists, chemical engineers, toxicologists, regulatory risk assessors, product stewards. I mean, these are really smart people, and they came and worked with us for many, many months in 2009, hammering out what are we for in TSCA modernization, and why, and how do we articulate that. And that began then a public statement by Cal Dooley in 2009 before the House Energy and Commerce Committee, laying out what we were for. And then we continued to refine that, and we had principles in mid-2009 as well, 10 principles. The most threshold principle of which is chemicals should be safe under their intended conditions of use. And that was to us just the centerpiece of our views on TSCA modernization. From there, I think the story begins to sound a lot like the ones we've heard so far. But we have been, since that time, committed to this vision of a modernized TSCA, one that restores the public's confidence in the regulation of chemicals in the United States. That is, I think, the key piece. One where EPA more systematically prioritizes really which chemicals need a full risk evaluation and which ones may be low priorities and not needing that deeper dive right off the bat. We want the EPA to evaluate risk under their conditions of use, and that I think is again central, and one in which science must be the basis for EPA's risk-based decisions. These are at the heart of what we're for, and these are, I think, what we see in the Lautenberg Chemical Safety Act. One of the keys to getting these messages out there and getting Congress to understand why we supported changes to TSCA, and in essence asking for more regulation of the products that we make. When we first started trying to go to the Hill and asking, for staff to sit with us and talk about these principles, you get a lot of glazed eyes. What are you talking about? And why are you, asking us for this? Why would we want to go here? Would say some of the members of Congress. And at that time, we began to realize that it's a very difficult area of law to explain, number one, and number two, manufacturing chemicals in the world of industrial, commercial chemicals that are used in all the products that we all come to use every day. It's a hard thing to explain unless you have those users of those chemicals with you on the Hill explaining why this is important. And so the coalition of business and industry groups that we began to build in 2009, 2010 grew to be a coalition of some 200 trade associations in this town. From the people that make the shoes you're wearing, the clothes you've got on your back, your car, your cell phone, all of these trade associations realized that this was such an important law to get right so that they could continue to make their products, but knowing full well, too, that those products were safe as used. So I think that was another sort of piece of how this happened and worked, because we helped Congress understand, this wasn't just about environment, health and safety. It was, but not just that. It's also about commerce and what's needed to make all the things that we use in today's world, and yet make sure that those can be used safely. So to me, that was a big piece of the success here. Congress heard loud and clear. The business community needs this too. It's not just the chemical industry. It's the economy of the United States needs this law improved. So I will end there and pass it.
Thank you, Sarah. And David?
Thanks. Thanks for having me. I've got the maybe unenviable task of providing some counterpoint. Although not total disagreement, although I suddenly remembered an interview once that Henry Kissinger had where he was asked about some President Nixon's description of something, and he said, well, I'll write my memoirs after he writes his. So, so maybe this is why I went last. But one thing I think we can all agree on is the amount of work that went into this and the huge hours. I'm sure Jim knows my number by heart as well as I know his. I sometimes picture a map of all the different places in the country where I ended up having to have TSCA calls, often on days like this. So let me describe where NRDC was and is. We were also part of the Safer Chemicals Healthy Family Coalition, and basically what I'm saying I think applies to them too. So our final position on the bill was that we neither supported nor opposed it. And the reason for that was not just an inability to make a decision, was actually because there were important improvements in the bill. It is the first new environmental law in, we would say, 20 years since FPPA and Safe Drinking Water Act, but a long time. And it has some important changes. It gives Jim a program he can actually work on. It makes chemicals evaluated on health, not just cost. It has the deadlines that were talked about, has fees. I mean, there's a whole list of things, obviously. There are also a number of things that continue to trouble us deeply about the bill. It creates, we think, a very bad precedent on preemption in that states are preempted before the federal government actually makes a ruling on what it's going to do. There are a number of areas of the bill that could lead to rollbacks in current authority the EPA has on things like imports. And there's also a lot in the bill that will, I'm glad Jim is looking forward to implementation. We talked about that at the bill signing, but a lot of this, even more than usual, will depend on implementation. Some of that is the nature of the law, so the kind of safety standard that was put in, which again, happily doesn't involve cost, hasn't been tested. That's just the nature of it. There are other things that will depend on implementation because of the way the bill was written, where it could have been written differently. So our feeling was this bill made some important strides. It could be even better, and not just better in the fact that every bill could be better, but it has some deficiencies that really disturb us, and a number of things that remain up for grabs. Our position, I'm glad Richard went back to the beginning because otherwise I'd feel more guilty going back to the beginning, but that is the most important thing. There is a book to be written about this. We're barely scratching the surface, which is probably a very good thing, and not just for time reasons, but because it's not sort of clear how that bill appeared. But as Richard kind of hinted at, and I'll say more bluntly than a way he'd agree on, the bill that was that Senator Lautenberg and Senator Vitter first introduced was, to our point of view, an atrocious bill. And while it is indeed, as everyone here has remarked, really hard to be worse than current law, that bill managed to do it. And that wasn't even a close call. It basically enabled EPA to declare chemicals safe on the basis of almost no information, while preempting states even when EPA hadn't actually rigorously reviewed a chemical. So despite that, our position, and like Richard described EDF's situation, we had very little time to figure out what to do. We decided, look, it's a bipartisan bill. It may not be going away. We've been working on TSCA a long time. This is a terrible starting point, but it's a starting point. And so we could have said, let's kill this now. We wouldn't have necessarily mean it happened that way, but it would have at least made it harder. We said, this bill is bad. It can't go forward in the way that it is now, but we are willing to continue to negotiate on these issues. And there really was probably hardly a time in the last 3 years, sometimes a lot of time with Jonathan, sometimes less, but that we weren't involved in trying to push changes in the bill. And a lot of the
strong points of the bill actually came out of some of those things we were pushing. The enforceable deadlines, for example, was something that we pressed on right from the outset. There were the strategic sort of question that separated some of us. Some people felt that the worst thing that could happen would be for this to fall apart, and some of us felt the worst thing that could happen would be to end up with a bad bill. And so we were in that latter camp, and kept pressing. There were numerous points, including the language that the trio got into committee, which was, as Senator Udall mentioned, a very important turning point, where it was another weekend worth of work for them and phone calls for some of the rest of us, where we were told, you can't, if you push that one more thing, the whole thing is falling apart. And we pushed, and they said, all right, we'll try it, and it got in the bill. So there was, the question in legislation always is, sort of this twin thing of how much do you push where you, finally do yourself harm, and when do you okay something that you think is really not good enough, but it's the most you can have. That's always a judgment. Our judgment on that was often different from some of the people on this panel, and I think on many of the items it was borne out. And in the end, I think the bill is better for that, even if we're less excited by the final result than some people here. I think a lot, again, will depend very much on the implementation, for all the reasons that I've mentioned and others have talked about. I think one lesson is it's always very tricky to figure out where that point is about how to push, and it's worth continuing to try. The line that's often used in Washington, which is an important lesson, is the perfect is the enemy of the good. Sometimes we forget the bad is also the enemy of the good. And there, if you've got a bill that's actually, or a provision that's actually bad, continuing to push is often the right thing to do. I'd say, again, I'll stop with that pretty much. Richard talked about how it feels like a mountain. I would say during it felt more like a virus. I think every one of us whom it touched, got a little bit, ill and dyspeptic, and the amount of personal investment in this that everybody had over this time was both necessary and often very difficult. But I think, again, we'll see how it works from here on in, but the fact that the bill exists shouldn't, I don't think it's to anyone's advantage to have that paper over the difficult choices that were made. The fact that a lot of how those turn out remains to be seen, and that this bill, like any, took a lot of pushing from different places, often uphill, to use the mountain analogy again, to get where we are right now. So, thanks.
All right. Well, thank you, David, and I want to thank all of the panelists. We do have time for questions, and I think that's an important part of this, so I want to open it up and see if we have questions in the audience. I think you have one behind you.
Do you have any lessons we could take from the process of TSCA reform to apply to reforming other environmental statutes, or even creating new ones?
Thank you.
I have one. I think one of the things that a lot of people don't appreciate, at least on the House side, the House Energy and Commerce Committee has very broad jurisdiction. We have healthcare, telecommunications, energy, Federal Trade Commission. We have a lot of issues, including environmental issues. And it's a very, very busy committee. If you're going to try to do another one of these major environmental laws, you have to make sure it is a very high priority for the committee. TSCA doesn't happen without Fred Upton's personal decision to make it a very high priority. It's like dispatching trains on the railroad. You've got 6 trains, you've only got 4 tracks. Which trains go? And there were a number of times, critical moments in this entire process, where the members were not quite ready to go to subcommittee markup, for example. We needed another week of members discussing with each other, in getting there. Guess what that meant? That meant changing the entire calendar of the committee. That meant telling other subcommittees, you can't have that date. We're going to cancel your hearing because we're going to move TSCA up to this Tuesday, May 20th. And because of that, all these other changes cascade, makes a lot of people irritated. Healthcare gets sidetracked. Energy gets sidetracked because you can't do them all. And the fact that Chairman Upton made this a priority is frankly why TSCA got through the House twice. And if it's not a priority for the next chairman, it's not going to happen.
Yeah, to also add to that, I think that as you heard all the speakers here, there have become moments of luck and moments of timing, and so you need to be very strategic. First of all, you have to get like we were able to do, and it's remarkable, as David Golson said, that they had the restraint. They felt strongly, but they never wanted to completely blow it up. They wanted to participate. They wanted to put in suggestions. Had they walked away, had the chemical industry walked away, had EDF walked away, it would have blown up. And so you have to have a message and a strength of that message. One of the things I heard from everybody talk here is I just wanted to say compromise is not a bad word. We actually have people campaigning today, elected officials that say, I'm going to go to Washington, I'm not going to compromise. Well, that if you're going to elect somebody like that, you're not going to get anything done back here. And so you need to find champions on your environmental bills that also have political will, that they're willing to do more than just introduce a bill. They need to deal with everybody, every stakeholder, get them at the table, keep them at the table, work through the issue. And so you really need to do a lot of scrutiny of who it is that you're going to ask to be your key players or your champions, and are they the kinds of people that have shown a history of working through these kinds of issues. So it's and what David said is very important here. David McCarthy said, I mean, you know, visiting with the key people at the top of the chain, the ranking members and the chairman and chairwomen, what are their priorities? And I mean, if it's not their priority, you don't get off the dime. So,
Can I just add two things, maybe that go in different directions than each other. But one is most environmental laws passed by significant majorities in the Clean Water Act, which was initially vetoed. And that has made them stand the test of time, in addition to the way they were drafted. For different reasons, different players here decided they didn't want to just get a bill that squeaked through. The point at which you reached 60 mattered, but that wasn't the point at which you were going to move things. That, frankly, made it possible to push for more changes that were important. For example, the least burdensome language was out, but some of the language that was put in to substitute for it, we felt actually could replicate that problem. The final language could be better, but we don't think does that. So having that as a goal and a clear goal, rather than let's see if we can sneak this through, or at least eke out a victory, I think was very important. The other is there is a tendency now, because bipartisanship is so rare. I worked on the Hill 20 years for a moderate Republican. I'd certainly like to see people working together, but bipartisanship is so rare now that people then assume if it's bipartisan, you don't have to really read it. That's not. Bipartisanship is not a substitute for actually looking at the content. I mean, initially the sense was, oh, it's bipartisan. If you say anything against, a bipartisan bill, it's like killing the last unicorn or something. It matters what's in these, and the drafting really matters. I mean, some of the things we're most worried about, while a lot of it has been cleared up, and some of this is true in any bill, but there's still a lot of drafting questions, despite all of Jim's technical assistance and so forth, that need to be pounded out. It's hard, bill drafting is sort of a forgotten art in some ways, and it really matters, especially in a bill like this, where we all know this is going to be not only Jim's work, but litigators for some time before we figure out exactly how some of these provisions are going to be interpreted.
Thank you.
Hi, I've been very curious, and I'm a reporter with Bloomberg BNA. I've been very curious, as you went through this very long process, what were some of the really hard gives that you had to do on each of your sides, especially Senator Udall and David? And then what were some things that you didn't think you could get in the bill, and they're in there?
Whatever the hard gives. I think that the members really have to answer that question, because the bill reflects two things. It reflects the values of all the members, and I mean strong beliefs and values. It also reflects their commitment to get it done. So at certain points, things, for example, features of the House bill that there were more features of the Senate bill that were not in the House bill and vice versa. But getting the House to, and then there's more than one member of the House. So maybe for a particular provision such as prioritization, maybe it was easier for some in the House to give on that than for others. The preemption was a very difficult section. And part of that is because people have deep values and they also have strong concerns about what's going to happen in the future. And it is, I quite agree with David Golston, it is a little unpredictable. But I think that, I think the original House passed bill on preemption looks quite different from the bill that the President signed. So we had member involvement in all of those decisions, and members discussing it, listening carefully, listening to the explanations of other members, why they felt the way they did, and being moved by that. So it's hard to say what was like the give that, was there a give that we felt badly about giving at the end? Not really.
I would say that one of the dynamics here, and I thought that it was particularly gracious in a way and generous of the Republican. I'm only talking the Senate now. The Republican majority in the Senate was as we were reaching to get the bill first through. Well, actually, they were the minority. So the first year and a half, the Democrats were the majority. But we were working through the bill, and it was clear to me that whenever we came up with democratic ideas, that they were willing to work with us. And then when they moved into the majority and could have started again, whether the issue's preemption, whether it had to do with the various technicalities that everybody talked about here, it was always the Republicans willing to say, okay, well, if you need this to get your people aboard, we feel that in working with you and working on the structure of the language, then we'll try to do everything we can to give it to you. And so I think it wasn't necessarily particular issues. It was more about trying to have a comfort level of the people that were the senators that were working on the bill to understand what was there. What David Golston said, really true, and then what we always want people to do from the outside is read the bloody bill and figure out what it says and give constructive criticism. And boy, if you would have told me that in a Republican Congress we were going to keep moving this bill for changes to bring more Democrats aboard, it showed a great deal of restraint and generosity on their part to do it. Now, I don't think, if you really look at it, I don't think they gave up a lot. It was massaging the language. It was having people understand more what was happening there. And as we said on preemption, when you got to the final The final difference between the Senate and the House, there were some pretty dramatic changes that brought people aboard, and those came through, I think, a comfort level of understanding as you moved through the process what was happening with the entire bill, and that it was an improvement on where we were. Can just add?
Let's go to Richard.
Yeah, sure.
I think there are two things about this that were not necessarily unique, but helped a lot. One is this issue is about health more than the environment, and I think that plays a little bit differently on Capitol Hill, even in an environment with a lot of anti-EPA sentiment. So there were members on both sides of the aisle that were moved by health issues because someone in their family was having trouble conceiving a child, or other things that were being, there's growing evidence are linked to chemical exposure. So it appeals across party lines, if you will, on that. The other thing I do want to come back to was this common ground that emerged because the industry itself, both the chemical industry and the broader business community, were facing a crisis of confidence, and frankly still are. And that meant that they weren't just looking to get everything they wanted in a bill and get it through just to be able to say it was done. Now, I'm not saying they were paper tigers, they but I think there was an ability to craft something that truly does give EPA more authority, truly does significantly strengthen its hand, because without that, it's not going to solve their problem. And that is not always the case. I think that was the result of a lot of the factors we've talked about, but it created a dynamic where there was more alignment than might otherwise usually be the case.
I agree with everything Richard just said. On some specifics, and the issue always is, as a number of us have said directly or not, how much weight the traffic will bear on some of these things. I think preemption clearly was the toughest issue from the first day to the last, and it was actually it was one final agreement on preemption the very last day. I mean, that didn't really come together until the very last morning. And one reason it was hard is there are changes in preemption that were baked in early that are big changes, and because they're baked in early don't get discussed as much. For example, EPA now can declare a chemical safe and states are preempted. There's nothing like that in current law in terms of a preemption provision, which is a broadening of preemption. I'd say there are, because there were so many things in this bill, there are, provisions that were disturbing that didn't get a lot of attention, the extent to which industry gets to set the agenda for EPA in terms of which chemicals review, which actually wasn't in the bill until pretty late and then kept getting larger and then got finally scaled back to half. And there's actually still a technical issue with that about what happens when fees run out. And one of the biggest issues for NRDC in particular, and Richard alluded to it, was the language about low priority, which originally was sort of a trapdoor in the whole bill from our point of view, got considerably narrowed, although we still have, that's one of the areas where EPA implementation decisions will be very important, how they actually interpret low priority. And one important change that we got through the various senators was making sure that low priority decisions could be challenged, low priority designations could be challenged in court, which was something that we pushed for assiduously. Jonathan might use a different word, but for a long time.
Well, thank you to all of our panelists. I think this has been a very interesting, stimulating discussion. I want to thank the people in the audience for the questions. We're very pleased to have had this opportunity. So thank you all.